So, very good morning, all the participants. This is the second session on Companies Act in Malaysia. I have already shared my first video on Companies Act in Malaysia, which has got very good response. So, let me start with my second session. And these are all very basic videos which tend to create an awareness, basically meant for students. So I hope my screen is visible to you. So Companies Act, Financial Governance and Audit Framework. So in this session, we would learn what are the responsibilities of the directors, what are the requirements as to audit, and what are the financial statement compliance standards. Now, let us see the director's responsibilities and what is the timeline for these responsibilities. So at incorporation stage, whenever directors are appointed, company constitution is adopted. So first statutory obligations begin. Within 18 months, first financial statements are to be prepared and audited, and they are to be presented to members at first annual general meeting. Within 6 months, annually, so subsequent financial statements, they are due after each financial year end. Right? So whenever a financial year ends, within 6 months, this is an annual responsibility of the directors. And before AGM, financial statements are presented to members, directors' report is tabled, and auditor's report is considered by the directors. Now, let us see the timing. Financial statement preparation requirements. So first statements, they are due within 18 months from the incorporation for the first financial period, and subsequent statements, they are due within 6 months after each financial year end. What is the requirement? Basically, whatever financial statements you are preparing, they must give a true and fair view, including auditor's remuneration, retirement benefits, compensation for loss of office, and auditor fees. Board approval stipulation is there. So statements must be approved by the board and they should be signed by at least 2 directors, and statutory declaration is to be attached. Consolidated financial statement requirements. So there is a requirement regarding group reporting. So it must include all subsidiaries for the financial year in which the holding company is reporting. The scope is to provide a true and fair view of the combined financial position of the group, and compliance is that it must comply with the applicable Malaysian accounting standards, MFRS or MPARS. Disclosure rules. Exclusion disclosure. If any subsidiary is excluded from consolidation, reasons must be fully disclosed in the notes. Subsidiary financial statements. Each subsidiary is also required to prepare separate financial statements. An audit requirement is also there. So consolidated statements must be audited by approved company auditor. Director's statement and report requirements. Director's statement. So there should be a signed statement confirming that the financial statements give a true and fair view, proper accounting records have been maintained, and the accounting standards have been duly complied with. Director's report, it must accompany the financial statements. It must cover the principal activities undertaken by the company, the results, dividends declared, reserves, directors' names and interests should also be appropriately disclosed. Regarding the going concern, directors are required to assess the company's ability to continue as a going concern, and they should disclose any material uncertainties in this regard, if any. There is a stipulation regarding the remuneration. So directors' remuneration, retirement benefits, and compensation for loss of office, it must be disclosed in the director's report. If there are any post-balance sheet events, so material events after the balance sheet date must be disclosed in notes to financial statements. Now let us see some of the requirements regarding auditor appointment and qualification. So only approved company auditors which are registered with Malaysian Institute of Accountants and approved by Ministry of Finance may audit company accounts. So there is only approved company auditors are authorized to audit the company accounts. Independent requirement is there. So auditors must be independent of the company. They cannot be officer, employee, or have any financial interest in the company. Appointment is to be done at AGM. So auditor is to be appointed at annual general meeting, and the auditor holds office until the end of the next annual general meeting unless he is removed or resigned or disqualified. In case of casual vacancy, board may fill the casual vacancy in auditor position, and appointment is effective in such cases until next annual general meeting. Removal of auditor. Auditor may be removed by ordinary resolution with special notice, but there is a right to make representations to members in case the auditor feels so. In case of resignation, the auditor may resign but must lodge notice with registrar and statement of circumstances if relevant. Now let us have a look at the auditor's rights and duties. Rights of auditor. The auditor has the right to access all the books, accounts, and records of the company at all times. There is a right to information. The auditor is entitled to require from the officers all information and explanation which are deemed necessary. Attendance at AGM. The auditor has the right to attend any AGM of the company and to be heard on matters concerning the audit. There are certain audit report obligations also. Audit report must report to members whether statements give true and fair view, whether proper records have been kept, whether statements comply with the act. In case of qualified report, auditor must qualify the report if statements do not give true and fair view or records are deemed inadequate. There is a criminal liability which can be fastened to the auditor in case he makes false statement in audit report, and the auditor may be liable to prosecution also. Annual general meeting requirement. When it is required, every company must hold AGM once in each calendar year, and first AGM is to be held within 18 months of incorporation. Regarding notice requirements, at least 14 days notice is required for private companies, and for public companies it is 21 days, and it is longer for special resolutions. What is the business to be transacted at AGM? Presentation of financial statements, declaration of dividends, re-election of directors, appointment of auditors. What is the quorum? Prescribed quorum must be met. Typically, 2 members personally present for private companies. And minutes of AGM must be recorded and signed by chairperson, and they are to be kept at registered office for at least 7 years. Regarding dividend declaration and restrictions. So what is the source of dividends? Dividends can be sourced only, and dividends may only be paid from distributable profits, and no dividend can be declared out of capital. There is a stipulation regarding board declaration. Interim dividends are to be declared by the board, and final dividends are to be declared by members at AGM. Directors may be held personally liable if they declare dividends when the company is insolvent or unable to pay the debts. Preference dividends must be paid before ordinary dividends, and cumulative dividends accrue if not paid in prior years. Unlawful dividends. If members who receive dividends knowing that they are unlawful must repay the amount received. Now regarding small companies audit exemption. What is the qualifying criteria for small companies? So private companies with annual revenue less than 3 million ringgits or assets less than 3 million ringgits, or those who are having fewer than 30 employees are normally exempted. But they must satisfy at least 2 of these 3 criteria. So company must satisfy at least 2 out of 3 criteria in each of the current and preceding financial year. And the criteria are on annual revenue, on assets, and employees. They are exempt from audit requirement, but still they are required to prepare financial statement and lodge such financial statements with the registrar. Directors must certify financial statements which present a true and fair view, and they remain liable for accuracy despite the exemption from audit requirements in case of small companies. There is a provision for withdrawal of exemption also. So members holding 5% or more may request audit, and registrar may direct audit if public interest so requires. Now let us see the requirements regarding accounting records. What are the stipulations regarding retention and access? Accounting records must include day-to-day entries, assets and liabilities, statements of goods sold or purchased, names of persons, transactions made. Retention period is minimum 7 years from the date of the transaction, and it is longer for ongoing transactions or litigation. Records must be kept at registered office or such other place in Malaysia as directors think fit. There are some penalties also which are leviable in case these requirements are not met. Let us first see the inspection rights. So directors may inspect at all times, members may inspect on giving notice, and auditors have full access at all times. Regarding electronic records, they are acceptable if readily accessible, printable, and protected against unauthorized alteration. But if there is a failure to maintain records, then officer who fails to maintain adequate accounting records is deemed guilty of offense, and there can be personal liability as well. So what are the key takeaways on this financial governance and audit framework? Number one, directors are personally responsible for preparing financial statements that give a true and fair view. First financial statements are due within 18 months of incorporation and subsequently within 6 months of the year end. Only approved company auditors may audit accounts. Auditors must be independent of the company. Consolidated financial statements must include all subsidiaries, and if there are any exclusions, then they must be disclosed. Small private companies, they are exempted from audit in case the revenue, assets or employees, they are below a particular threshold. Accounting records must be maintained for minimum 7 years and accessible to auditors at all times. Now let us see the procedure regarding members meetings and procedure. I hope my screen is visible. So members meetings and procedure. Power of members to require circulation of statements. Tier 1, share capital companies. So members with 2.5% of paid up capital, excluding treasury shares, may require circulation of a statement. Tier 2, 50 member threshold, at least 50 members holding shares with average paid up capital sum of at least 500 ringgits may requisition the circulation. Tier 3, in case of no share capital, for companies without share capital, members representing at least 2.5% of total voting rights may require circulation of statements. And what is the statement specifications? Not more than 1000 words, and they are to be submitted in hard copy or electronic form, but they must be signed or authenticated. Next is submission deadlines and request format. Resolutions. So there is a 28-day rule. Resolutions. For statements relating to resolutions, request must be received at least 28 days before the meeting. And format, it could be in hard copy or electronic form, and it is to be accompanied by the statement, and it must be signed or authenticated by the requisitioning members. Regarding other statements, there is a 7-day rule. So statements other than resolutions, right? So other statements, for statements not relating to resolutions, request must be received at least 7 days before the meeting. Unless the company resolves otherwise, expenses for circulation are paid by requisitioning members. And compliance is not binding unless sum is sufficient to cover expenses is deposited at least 1 week before the meeting. Now section 314 to 316, they deal with the notice of meetings. Section 314 talks of the notice period. So in case of private companies, minimum 14 days notice is required. In case of public companies, minimum 21 days, and shorter notice is valid if all members consent to a shorter notice. Section 315 talks of the notice contents. So the contents of the notice, they must state the date, time, place, and general nature of business to be transacted. Section 316 deals with service of notice, and it says that notice may be served personally, by post, or electronically, and it is deemed served 48 hours of the posting. Section 317 and 318 talks of the quorum and the chairperson of the meeting. So quorum requirement, no business transacted at any meeting unless quorum is present when meeting proceeds to business. What is the default quorum? Unless constitution provides otherwise, 2 members personally present form a quorum. Single member quorum. So court may order meeting with 1 member present where impracticable to call meeting in any other manner. Chairperson appointment. Members elect chairperson by show of hands, and director nominated by the board usually chairs the meeting. And chairperson powers. The powers of the chairperson include adjournment of meeting with consent of quorum present, and it must adjourn if directed by the meeting. Section 315 to 321 talks of the voting rights and procedure. So the default voting method is show of hands at the meeting and 1 vote per member present regardless of the number of shares held. Voting may be done by poll also. So poll may be demanded by chairperson or prescribed minimum members, and votes weighted by shares held. Who may demand poll? Chairperson, at least 2 members, or members holding 10% or more of the total voting rights, or members holding 10% or more of paid up capital. In case of equality of votes, so there is a concept of a casting vote. So chairperson has a casting vote where votes are equal unless constitution provides otherwise. Regarding proxy voting, members may appoint proxy to attend and vote, and proxy may be a member or non-member of company. Regarding corporate representatives, corporate member may appoint representative by resolution of its board to attend and vote. Sections 322 and 323 talk of the proxy appointments. Appointment rule. So there is a right to appoint proxy. Every member entitled to attend meeting has right to appoint 1 or more proxies. The proxy instrument, the appointment must be in writing, signed by member or attorney, and prescribed form is acceptable. And deposit deadline, the proxy instrument must be deposited at registered office not less than 48 hours before the meeting. Now let us see the proxy rights and revocation. What are the rights of proxy? So proxy has same right as member to speak, vote on a poll, and demand a poll. Regarding revocation, proxy appointment is automatically revoked if member attends meeting in person. And in case of multiple proxies, member who holds shares as bare trustee may appoint different proxies for different shareholdings. Now section 324 to 326 regarding resolutions. What are the types of resolutions and what are the requirements for passing such resolution? As we know, there are different types of resolutions. So ordinary resolution is deemed to be passed by simple majority. That means more than 50% of the vote cast, and it is used for routine business. Special resolution is deemed as passed if it is passed by 75% majority, and it is required in case of alteration of constitution, change of company name, capital reduction, winding up, mainly major decisions. Then written resolution. Private companies may pass resolutions without meeting and it must be signed by all eligible members. Circulation of written resolution, proposed resolution must be circulated to all eligible members, and there is a 28-day period to respond to a written resolution, which is circulated by way of circulation. Effectiveness: written resolution is passed when requisite majority is achieved and it is effective from the date last signature is received. Section 327 and 328, they deal with the minutes and record keeping. Minutes of meeting: company must keep minutes of all proceedings at general meetings and board meetings. There is a signing requirement that minutes must be signed by chairperson of meeting at which proceedings occurred or next meeting. Evidentiary value: so signed minutes are prima facie evidence of proceedings recorded therein. Access and retention: minutes must be kept at registered office and they must be retained for at least 7 years after the meeting date. Members are entitled to inspect minutes of general meetings and directors may inspect all minutes. Any officer who fails to record or maintain minutes and commits offence, and he may find up to 20,000 ringgits. Section 329 to 330. Members' rights. Access to information. Register of members. Any person may inspect a register of members during business hours at registered office free of charge. Members may inspect register of directors and their interests during business hours. Copies of documents. Members are entitled to copies of the Constitution, financial statements, and director's report on request. And company may charge the prescribed fee for copies and must be provided within 7 days of request. Court may compel company to provide access or copies if request is refused without valid reason. Section 331 to 333. Electronic meetings and modern provisions. So there is a concept of virtual meetings. So company constitution may permit or require members to participate in meetings by electronic means. Technology requirements: electronic meeting facilities must allow real-time participation, voting, and communication. There is a concept of hybrid meetings also. So meetings may combine physical attendance with electronic participation for geographically dispersed members. Then electronic voting. Electronic poll voting systems may be used subject to adequate safeguards and audit trails. Consent required. All members must consent to holding meeting entirely by electronic means without physical venue. So let us see the takeaways for members' meetings and procedures. Members with 2.5% of paid up capital may require company to circulate statements before meetings. Notice period is minimum 14 days in case of private companies and 21 days in case of public companies for general meetings. Quorum is normally minimum 2 members present and poll may be demanded by 2 or more members or holding 10% or more of voting rights. Special resolutions require 75% majority and they are used for constitutional changes and capital reduction. Minutes must be signed, retained for 7 years and available for members' inspection at a registered office. Electronic and hybrid meetings are permissible subject to constitution and members' consent. Okay. Now, let me share my screen again with you. Regarding the appointment of receivers. So section 371, it deals with appointment of receivers. Debenture holder authority, power to appoint receiver or receiver and manager via written instrument upon event of default. Multiple appointment options are there. So they may appoint 2 or more and they may appoint additional receiver or manager or replace a vacant position. There is a role flexibility. A receiver can act as both receiver and manager unless expressly provided otherwise in the instrument. What is the status of the agent? So receiver or manager is an agent of the company, acts on behalf of the company, and it represents company interests. Multiple appointees, when multiple appointees are there, so functions may be performed by anyone or jointly by all, and reference to receiver applies to whichever one is acting as a receiver. What are the liability implications? So agent status means company, not debenture holder. So generally liable for receiver's acts. Section 372 deals with court appointment of receiver or manager. So court may appoint receiver when company defaults on debt or obligations which are secured by debentures or charge. Court may appoint to protect property at risk of being damaged, destroyed, or wasted by current management. So primary purpose is preservation and realization of secured assets for benefit of debenture holders. So court has wide discretion. It considers all circumstances, including impact on other creditors and employees. Now regarding the qualifications of receiver or manager. So only an approved liquidator or other person approved by minister may be appointed as receiver or manager. What are the disqualifications? So an undischarged bankrupt, somebody who is convicted of offense involving fraud, dishonesty, or moral turpitude is or any disqualified director cannot be appointed as a receiver or manager. Officer of company is disqualified. So any officer or employee of the company, including auditor, may not be appointed as receiver. There is a requirement of acceptance of appointment also. So person must accept appointment in writing within prescribed period, and acceptance constitutes confirmation of qualifications. Section 374 deals with the duties of the receiver upon appointment. First of all, there is a duty regarding notification. So it must notify the company of the appointment within 7 days, and company must notify the registrar within 14 days. Regarding statement of affairs, so it may require the officers to submit statement of company's affairs within 14 days of request. Regarding report to registrar, it must lodge a report with registrar within 2 months of appointment, and which should be updated every 6 months. Now, what are the property and record duties of the receiver? Property inventory. It must prepare inventory of all property in custody, control, or possession within 14 days. Regarding books and records, the receiver is required to preserve all company books, records, and documents. It cannot destroy without court approval. And there is a priority of claims. It must identify and comply with priority claims before distributing proceeds to debenture holders. Section 375 deals with the powers of receiver or manager. The receiver has the power to sell or otherwise dispose of property subject to the charge for the purpose of repaying secured debts. Just a minute. Management powers. There is a power to carry on the business of the company if he is a receiver manager to preserve going concern value. The receiver may institute, continue, or defend legal proceedings in the name of the company. Receiver is authorized to appoint agents, employees, and professional advisors which are necessary for proper conduct of receivership. He may borrow money and grant security over company assets if it is necessary and court approved. So receiver may also compromise claims against the company with court approval for amounts above any prescribed threshold. Regarding preferential statements, there is a priority order. So receiver must pay from assets in prescribed order. Number 1 is the cost of the receivership. Second is preferential creditors. Third is secured debenture holders. So preferential creditors include employees' wages up to a specified amount per employee, EPF and SOCSO contributions and taxes due to government. The extent of priority is the preferential claims have priority only over floating charge holders, not over fixed charge holders. So what is the payment sequence? First is fixed charge proceeds, then preferential creditors, then floating charge holders, unsecured creditors, and then members. Any surplus which is remains after satisfying all claims is returned to company or its liquidator. If there are disputed claims, then receiver must set aside funds for disputed claims pending resolution by court. Section 377 and 378. Liability of the receiver. So receiver may be held personally liable for contracts entered into during receivership unless contract excludes liability. There is a right of indemnity also. So receiver is entitled to be indemnified out of company property for liabilities incurred in proper conduct of duties. Receiver is liable to company for gross negligence, willful misconduct, or bad faith in conduct of receivership. There is a liability to third parties also. So third parties dealing with receiver in good faith are protected and cannot avoid contracts on the basis of the receiver's excess of authority. Section 379 to 381 deal with vacation of office and end of receivership. Receiver may resign on giving prescribed notice to company or court if it is appointed by the court, and debenture holders. Removal by the court. So court may also remove a receiver if he is found guilty of misconduct or failure to perform duties or on other sufficient causes. Debenture holders may also remove a receiver if it is instrument appointed. So they may also remove receiver and appoint a replacement. In case of death or incapacity, appointment automatically terminates on death or legal incapacity of receiver. On vacation, receiver must lodge final report and accounts with registrar within 2 months. And all company property must be handed to the company, liquidator, or subsequent receiver as appropriate in the circumstances. Section 382 to 386, they deal with winding up during receivership. So receivership versus winding up. So there could be concurrent proceedings. So company may be wound up while receiver is in office and receivership does not automatically end. So receiver continues to act during liquidation in respect of assets subject to the charge. And liquidator's power, liquidator may apply to the court to terminate receivership if it would be beneficial to unsecured creditors. So there is a concept of cooperation framework. So cooperation is required from the receiver and liquidator. So receiver and liquidator, they are required to cooperate, share information, and avoid any conflicting actions. If any surplus remains after discharging the secured debt, it must be handed over to the liquidator for distribution. And court may give directions to resolve conflict between receivers and liquidators' duties. So let us see the key takeaways of receivers and receiver managers. So receiver may be appointed by instrument, debenture holder, or by court order upon default or risk to property. Only an approved liquidator or ministerially approved person may act as receiver or manager. A receiver must notify company within 7 days and lodge report with registrar within 2 months of appointment. Fixed charge holders take priority over preferential creditors. Floating charge holders rank after preferential creditors. Receiver is personally liable for contracts during receivership unless liability is expressly excluded. And final report and accounts must be lodged with registrar within 2 months of vacating office. Just a minute. So we have seen the provisions regarding receivers and managers. Now let us see the winding up provisions, which is the last in this present session. So winding up, let us have an overview of the winding up provisions. Sections 441 to 452. One is the stage 1, which deals with the attachment restrictions. So this is the initial stage where creditor claims are frozen and asset attachments are restricted to preserve company property for equitable distribution. Second stage is property distribution, orderly valuation and allocation of company assets according to statutory priority of claims. Stage 3 is the liquidator appointment. So official designation of an independent administrator to oversee winding up and protect stakeholder interests. Stage 4 is the exercise of powers. So liquidator performs statutory duties which include debt verification, asset realization and interim distributions. And stage 5 is the final settlement. On completion of all claims processing, final set distribution and formal dissolution of the company takes place. Now let us see the framework regarding property protection and distribution. There are restrictions on attachment. So any attachment, sequestration, distress or execution against company estate after winding up commencement is void. No further proceedings, no action or proceeding can be continued against the company without the leave of the court after a winding up order has been issued. Distribution rules, distribution of property. So company property is applied to satisfy liabilities equally and remaining property is distributed among members according to their rights. Court may grant leave for creditors to continue enforcement in exceptional circumstances. There is a priority of claims, secured creditors, then preferential creditors, unsecured creditors, and members are to be paid in that order. Now let us see the provisions regarding the authority of the liquidator and powers of the liquidator, which are given in sections 443 to 445. Asset realization. So there is a power to sell company property by public auction or private contract, and it may defer sale pending better market conditions. It may sue and be sued in the name of the company, prosecute claims for recovery of assets, and the liquidator may also defend company's interests. Regarding employee matters, so liquidator is authorized to terminate employment contracts. It can pay outstanding wages as preferential debts, and it can negotiate new contracts if continuing in business during liquidation or winding. Contract performance. It may adopt or disclaim company contracts, profitable contracts adopted, and onerous contracts are disclaimed. Borrow and grant security. It may borrow with court approval and grant security over company assets where necessary for winding up. Regarding distribution, it may make interim distributions to creditors and final distribution after all claims are settled. Now regarding voluntary winding, what are the types and what is the procedure? So there is a concept of members voluntary winding up. When the company is solvent and directors make solvency declaration, the company can pay all debts within 12 months. Creditors voluntary winding up, company is insolvent, directors cannot make solvency declaration, and creditors have major role in choosing liquidator. Liquidator appointment, members appoint liquidator in members voluntary winding up, and creditors nominate liquidator in case of creditors voluntary winding up. Regarding requirements of meeting, creditors meeting must be held within 14 days of members meeting for creditors voluntary winding up. And what are the powers of the liquidator? So powers of the liquidator are almost similar in case of members voluntary winding up and creditors voluntary winding up. But creditors voluntary winding up is subject to the Committee of Inspection oversight. Now let us revise the procedure regarding this compulsory winding up. Court petition process. What are the grounds? Special resolution, failure to hold statutory meeting, suspension of business, inability to pay debts, and whenever it is considered just and equitable to wind up the company. So these are the grounds. Who may petition? Company itself may file the petition, creditors may file, contributories may file, registrar of companies may file, attorney general and securities commission may file for winding up of the company on any of the grounds, right? So court will hear the petition and it has the power to dismiss, adjourn or make winding up order, and official receiver becomes provisional liquidator. So official receiver acts until approved liquidator is appointed, and appointment is made at first creditor's meeting. And what is the effect of the order? So all disposition of property after commencement of winding up are void and no legal proceedings can be taken or continued without the leave of the court. Now let us see the liquidator's appointment and qualifications. Who may be appointed? Only an approved liquidator, which is registered with Malaysian Institute of Accountants and approved by Minister of Finance, may act as liquidator in creditors, voluntary or court winding up. Official receiver, government official who acts as liquidator in compulsory winding up until private liquidator is appointed. What are the requirements regarding qualification? It must be approved by Minister of Finance, licensed insolvency practitioner, and there should not be any disqualifying factors. Oversight and remuneration. Committee of inspection. In creditors voluntary winding up, committee of 3 to 5 creditors and contributories oversees the liquidator. Liquidator may be removed by court on application by creditors for misconduct or breach of duty. Remuneration is fixed by the creditors committee or court and it is paid from company assets as priority expense before any other payment. Proof of debt and creditor claims. Proof of debt. So creditors must file proof of debt with liquidator and formal affidavit or statutory declaration is required. Liquidator may admit proof in full or in part, but it must give reasons for rejection and creditors have the right to appeal to the court in case liquidator rejects their claims. Secured creditors have the option to realize the security on their own and prove for balance or value security and prove for full debt or surrender security and prove for full. So they have got this option. So they may either realize and prove for balance or surrender security and prove for full. Disputed claims. So liquidator may apply to court to determine validity of disputed claims and funds are set aside pending a resolution. Regarding contingent claims, so future or contingent claims may be admitted at estimated value to enable distribution. Regarding deadline for proof, so liquidator sets the deadline for proof. Creditors not proving by deadline may be excluded from interim distributions. Now priority of payments in winding up. So first priority is the costs of winding up, liquidator's remuneration, legal costs of winding up, cost of preserving and realizing the assets. Priority 2 is according to preferential debts, employee wages up to statutory limit, employee leave pay, EPF and SOXO contributions taxes. Priority 3 is according to floating charge holders, debenture holders secured by floating charge on company's assets. Fourth priority is given to unsecured creditors, trade creditors, unsecured debenture holders, bank overdrafts not secured by fixed charge. And fifth priority, the last priority is given to members or contributors. Here also preference shareholders are paid first and ordinary shareholders are paid last and only paid if all the debtors are settled. So there could be allegations of fraudulent and insolvent trading. So if business was carried on with intent to defraud the creditors, so court may declare persons knowingly party as personally liable for company debts. Directors may be personally liable if they allow company to incur debts when company is insolvent and they knew or ought to have known, right? So this is known as twilight zone. Who is liable? Directors, shadow directors, and any person which is party to fraudulent or insolvent trading may be held liable. What is the standard of knowledge? So there is a test of objectivity. The test of objectivity is, would a reasonably diligent person with director's general knowledge, skill and experience have known company was insolvent? What are the defenses available? Director can establish they took all reasonable steps to prevent company incurring the debt. And then there is a criminal liability for fraudulent trading and civil liability for insolvent trading. And there can be imprisonment up to 10 years in case the default is proved. Regarding dissolution and deregistration, liquidator will call the final meeting of creditors and contributors It will present all the final accounts and explains the conduct of winding. Liquidator shall file the final return with registrar within 1 week of final meeting, and it will include the final accounts. Company shall stand dissolved on the date of registration of final return, and it ceases to exist as legal entity from that date. And if there are any undistributed assets, so assets not distributed vest in the crown, registrar is notified and claims may be made within 12 years. Restoration to register, dissolved company may be restored within 15 years on application, and name may be revived, and company shall be deemed as never dissolved if restored. So what are the key takeaways on winding up provisions? On winding up commencement, all attachment and enforcement actions against company assets become void. Only an approved liquidator may act. Official receiver acts provisionally in compulsory winding up. Priority of payment is first of all costs, then preferential debts, floating charge, unsecured, and then members. Directors may be held personally liable for fraudulent trading and insolvent trading with criminal and civil consequences. Creditors must file proof of debt, and liquidator may admit or reject, but the route of court appeal is available. And company shall stand dissolved when registrar registers the final return, but it may be restored within 15 years of dissolution. So this is the end of the second session on Companies Act. It is considered to be an overview of the Companies Act, basically meant for students of company law. So if you are a student, so you can request me copies of the presentation also. I'll give my email address in comments, and I have framed certain MCQs also. So MCQs will also be sent to those persons who are interested in solving those MCQs, which are basically prepared on the basis of the various provisions of Companies Act, which will help you in getting a basic idea of the Companies Act. Thank you so much for watching this. You can subscribe to my channel also if you have liked this video. Thank you so much.